In this section, we are discussing about the problems and solutions with respect to company law. So the first problem is from the section kinds of company. So the problem, in a private limited company, it is discovered that there are in fact 204 members. On an inquiry, it is ascertained that 6 of such members have been employees of the company in the recent past and they have acquired their shares while they were still employees of the company. Is it necessary to convert the company into a public limited company? So here, private companies is defined in section 2 subclause 68. Section 2 subclause 68. Private company means a company which by its articles 1. Restrict the right to transfer its share. 2. Except in case of one-person company limits the number of its members to 200, where two or more persons hold one or more shares in a company jointly, they shall, for the purpose of this clause, be treated as a single member. In counting this number of the following persons are in counting this number, the following persons are excluded. So, who are excluded? That is A, persons who are in employment of the company, and B, persons who, having been formerly in the employment of the company, were members of the company while in the employment and have continued to be members of the members after the employment ceased. So two kind of persons are excluded while counting the limit of numbers, that is to 200 of public company. So what kind of the two classes of people that are excluded to be counted in this is one, persons who are currently in the employment of the company, and the second category is persons who, having been formerly in the employment of the company and were members of the company while in that employment and have continued to be members after the employment ceased. So these two categories of persons are not counted under the limit of 200. Now, the third clause prohibits any invitation to the public to subscribe or for any securities of the company. Now, as per section 2 subclause 68, a company to be registered as a private company must restrict its membership to 200 only. However, in counting this number of 200 members, employee members and ex-employee members, that is those who became members while in the employment of the company but now having ceased to be in the employment still continue to retain membership as per section 2 subclause 68 subclause 2 subclause A and B. So this is what we consider the exclusion class of persons excluded. So they are to be excluded. Thus, in the given problem, the company shall continue to be a private company, so no need for the conversion. Now, the next problem comes from foreign company. Here, analyze under the provisions of the Companies Act 2013 whether the following companies can be considered as foreign company. So the first question is, a company incorporated outside India and registered in Moscow, Russia, has installed its main server in Moscow for maintaining office automation software by cloud computing for its clients in India. So as per section 2 subclause 42, section 2 subclause 42 of the Companies Act 2013, a foreign company means any company or a body corporate incorporated outside India which has a place of business in India, whether by itself or through an agent, physically or through electronic mode, and conducts business activity in India in any other manner. Thus, it can be said that this company has a place of business, having a place of business in India through electronic mode and is conducting business activity in India. This company will be considered a foreign company. The next problem is, a company which is incorporated outside India employs agents in India but has no place of business in India. So here the foreign company means any company or body corporate incorporated outside India which has a place of business in India, whether by itself or through an agent, physically or through electronic mode, and conducts any business activity in India in any other means. So that is defined in section 2 subclause 42 of Companies Act 2013. So in this case also, company though had employed agents in India but have no place of business in India, so it cannot be termed as foreign company. And the next problem is a company incorporated outside India and is registered in Mauritius. All the business models, financial strategy, important decisions are carried and taken out at the board meeting held only in India. So here, company does not have a place of business in India, whether by itself or through an agent, physically or through electronic mode, and does not conduct any business activity in India in any other manner. So, mere holding of board meetings and executing business models, financial strategies, and important decisions in India cannot be termed as conducting business activity in India. This company will not be considered as a foreign company. So, what is a foreign company? A foreign company is defined in section 2 subclause 42, and it means any company or body incorporated outside India which has a place of business in India, whether by itself or through an agent, physically or through electronic mode, and conducts any business activity in India in any other manner. So that is the definition of foreign company. Now the next problem we have, that is a company incorporated outside India and registered in Australia has authorized Mr. X in India to source customers and subsequently to enter into contracts with them on behalf of the company. So here it can be said that this company has both place of business in India through an agent, physically or through electronic mode, and is conducting business activity in India. Thus, this company will be considered as a foreign company. Now, the next problem is with respect to the topic of government company. So, the problem: government today is a competitor with the public or private companies and corporations and doing trade or business or commerce. In doing so, the government is not doing it qua government. It joins the field of the competition in these diverse spheres and fields as government companies, as state trading corporations, and in many other forms under particular statutes. Explain. So that is a problem. Now, as per section 2 subclause 45, section 2 subclause 45 of the Companies Act 2013, government company means any company in which not less than 51% of the paid up share capital, that is 51% of the paid up share capital, is held by central government or any state government, or state governments, or partly by central and partly by state government. Now, holding of shares by municipal and other local authorities or statutory corporations, which are the government bodies, is not to be taken into consideration for this purpose. Government company includes a company which is a subsidiary of a government company. A government company is not required to use limited or private limited at the end of its name. A company brought into being under Companies Act has a separate existence, and law recognizes a company as a juristic person, separate and distinct from its members. So, the company is different from the government. This personification emerges from the moment of its incorporation and from the date the person subscribing to its memorandum of association and others joining it as members are regarded as body incorporated or corporate aggregate, and the new person begins to function as an entity. The right and obligations of a company are distinct from those of its shareholders. Therefore, the legal status of a government company is not affected just because the share capital of the company is contributed by the central government and all its shares are held by the President of India or the governor of a state and certain nominated officers of the government. Now, the next problem we have is from the topic guarantee company. What is meant by a guarantee company? State the similarities and dissimilarities between a guarantee company and a company having share capital. So, company limited by guarantee, that is defined in section 2 subclause 21 of Companies Act 2013. That is section 2 subclause 21. Now, it means it is defined as the company having the liability of its members limited by the memorandum to such amount as the members may respectively undertake by the memorandum to contribute to the assets of the company in the event of its being wound up. So a guarantee company or a company limited by guarantee is defined as the company having the liability on its members limited by the memorandum to such amount as the members may respectively undertake by the memorandum to contribute to the assets of the company in the event of its being wound up. Thus, the liability of members of a guarantee company is limited up to the stipulated sum mentioned in the memorandum. Members cannot be called upon to contribute beyond that stipulated sum. Now, similarities and dissimilarities. The common features between the guarantee company and share company are legal personality. So, the common feature is the legal personality and limited liability. In the later case, that is share company, the member's liability is limited by the amount remaining unpaid on the share. So, in share company, the liability of the members is limited by the amount remaining unpaid on the share which each member holds. Both of them have to state in their memorandum that the member's liability is limited. However, the point of distinction between the two types of companies is that the guarantee company, the members may be called upon to discharge their liability only after the commencement of the winding up and only subject to certain conditions. But in share company or company limited by shares, they may be called upon to do so at any time, either during the company's lifetime or during its winding up. So the similarity is the legal personality and limited liability, and the difference is how the liability is bound upon them. For guarantee company, the liability comes to them during the process of winding up, and it is to the stipulated sum as per memorandum. And with respect to share company, they may be called upon to pay the remaining unpaid amount on the shares during the lifetime of the company or during wound up. So that is the difference between the guarantee company and share company. Now the next problem we have is from unlimited company. An unlimited company is a company not having any limit on the liability of its members. Comment. Now, as per section 2 subclause 92, section 2 subclause 92, the Companies Act 2013, an unlimited company means a company not having any limit on the liability of its members. Thus, the maximum liability of the members of such a company in the event of its being wound up might stretch up to the full extent of their assets to meet the obligations of the company by contributing to its assets. So the people become personally liable. However, the members of an unlimited company are not liable directly to the creditors of the company, as in the case of a partners of a firm. The liability of the company is only towards the company, and in the event of its being wound up, only the liquidator can ask the members to contribute to the assets of the company, which will be used in discharge of the debts of the company. An unlimited company may or may not have share capital. The articles of association of an unlimited company must state the number of members with which the company is to be registered, and if the company has share capital, the amount of share capital with which the company is to be registered. This is discussed in section 5. So with respect to share capital, that is discussed in section 5, and an unlimited company is defined in section 2 subclause 92. Now, holding company and subsidiary company. The next problem is from the topic holding company and subsidiary company. Now, the problem is the paid up share capital of XYZ Private Company Limited is 20 lakhs, consisting of 2 lakh equity shares of rupees 10 each, fully paid up. ABC Private Limited and its subsidiary DEF Private Limited are holding 60,000 and 50,000 shares respectively in XYZ Private Company Limited. Now, examine the reference to the provisions of the Companies Act 2013 whether XYZ Private Company Limited is a subsidiary of ABC Private Limited. Would your answer be different if DEF Private Limited is holding 1,10,000 shares in XYZ Private Company Limited and no shares are held by ABC Private Limited in XYZ Private Limited. So the question, it is given that XYZ company has a total paid up share capital of 20 lakh and it has 2 lakh equity shares of rupees 10 each, and ABC Private Limited, fully paid by ABC Private Limited and its subsidiary DEF Private Limited. Now ABC holds 60,000 and DEF holds 50,000 respectively. Now the question is, we have to consider what are the positions of ABC and DEF here with respect to XYZ. Along with that, it is given that would the answer be different if DEF Private Limited was holding 1,10,000 shares. That is, initially they are holding 50,000. If it was 1,10,000, would the answer be different? So that is the problem here. Now the solution. Section 2 subclause 87 of the Companies Act provides that, so once again, section 2 subclause 87, it provides that a company shall be deemed to be the holding of another where it is either at its own or together with one or more of its subsidiary companies holds more than half of the total share of the share capital of the other. Once again, so by section 2 subclause 87, it provides that a company shall be deemed to be holding of another, that is holding company of another company, where it is either at its own or together with one or more of its subsidiary companies hold more than half of the total share capital of the other. Further, shares held or power exercisable by a subsidiary shall be treated as held or exercisable by the said company. Thus, the share held or power exercisable by a subsidiary shall be treated as held or exercisable by the holding company. Thus, in the given problem, XYZ Private Limited shall be deemed to be the subsidiary of ABC Private Limited, or ABC Private Limited becomes the holding company. Now, the second situation is rather simpler inasmuch as under explanation A to section 2 subclause 87, a company which is a subsidiary of a subsidiary shall also be deemed to be the subsidiary of the holding company. Accordingly, XYZ Private Limited shall be, on the basis of majority shareholding criteria, the subsidiary of DEF. That is, out of the 2 lakh shares, if DEF was to hold 1,10,000 shares, that is more than half. So XYZ becomes a subsidiary of DEF, whereas DEF itself is already a subsidiary of ABC. So here the XYZ Private Limited shall also be a subsidiary to ABC, because XYZ is a subsidiary of DEF, which in turn is a subsidiary of ABC. So XYZ also becomes a subsidiary of ABC. Now, subsidiary company. Section 2 subclause 87 clause 1 of Companies Act 2013 contemplates exercise of control by holding company on the composition of the board of directors of one or more companies, where such companies shall be construed to be subsidiary companies. Now, section 2 subclause 87 subclause 2 contemplates exercise or control of more than one half of the total share capital by a holding company on its own or together with one or more of its subsidiary companies. The effect of the provisions elucidating the concept of a subsidiary company is that if A Limited and its subsidiary B Limited hold together more than 50% of the total share capital of C Limited will be treated as a subsidiary of A Limited. It follows that B Limited is a subsidiary of A Limited and both A Limited and B Limited together hold more than 50% of the share capital of C Limited. C Limited will be subsidiary of A Limited. So this example or illustration is exactly the same as the situation of the problem we discussed right now. Now, subsidiary is constituted as an entity of which the holding company controls more than one half of the total share capital, either directly or indirectly, or controls the composition of the board of directors. The expression total share capital has been defined to mean the aggregate of the paid up equity share capital and convertible preference share capital. Now, holding company. In terms of Section 2, Subclause 46, Section 2, Subclause 46 of Companies Act 2013, holding company in relation to one or more other companies means a company of which such companies are subsidiary companies. In essence, a holding company is vested with the power to control the composition of the board of directors of a company and control more than one half of the total share capital of a company, the latter being a subsidiary company. Control which may exercise by holding company includes right to 1. Appoint majority of directors, and 2. Control the management or policy decision individually or in concert, directly or indirectly, including the exercise of control by virtue of the shareholding or management rights or shareholder agreements or voting agreements or in any other manner. So that is with holding company. Now, the next topic is association not for profit. A group of promoters propose to establish a company for charitable purposes without the addition of the word limited as part of its name. Discuss briefly the procedure to be followed in addition to the normal procedure for incorporation of a company. So here the relevant section is section 8. Once again, section 8 of Companies Act 2013. Now, association not for profit, where to satisfaction of the central government an association A is about to be formed as limited company for promoting commerce, art, science, religion, charity or any other useful object, and B intends to apply its profit, if any, or other income in promoting its objects, and C intends to prohibit the payment of any dividend to its members. The central government may, by license, direct that the association may be registered as a company with limited liability without an addition to its name of the word limited or the words private limited. Now, a firm may become a member of a company registered under section 8. Now, revocation of license. The central government may revoke the license granted to a company registered under section 8. 1. If the company contravenes any of the requirements of section 8 or any of the conditions subject to which the license was issued, or second, the affairs of the company are conducted fraudulently or in a manner violative of the objects of the company or prejudicial to public interest. Then the central government may direct the company to convert its status and change its name to add the word limited or the words private limited as the case may be to its name. A copy of the order of the central government as above must be given to the registrar. Where a license is revoked, the central government, after giving a reasonable opportunity of being heard, may, if it is satisfied that it is essential in the public interest, direct that the company be wound up or amalgamated with another company registered under section 8 and having similar objects. A company registered under section 8 shall amalgamate only with any other company registered under section 8 and having similar object. Now, if on the winding up or dissolution of such a company there remains after the satisfaction of its debt and liabilities any asset, they may be transferred to another company registered under section 8 and having similar object, subject to such condition as the tribunal may impose, or may be sold and proceed thereof credited to the rehabilitation and insolvency fund formed under section 269. So, rehabilitation and insolvency fund formed under section 269. And a similar question, that is Alpha Limited, a section 8 company with charitable objects, is planning to declare dividends in annual general meeting for the financial year ended in 31/3/2018. Mr. Chopra is holding 800 equity shares as on date. State whether the act of the company is according to the provisions of the Companies Act. So this is a prohibited condition that is in Companies Act. So the declaration of dividends by Alpha Limited is not permissible. It is one of the acts that is not permissible under Section 8. So that is with this section. Thank you for listening, and we have few more sections. In this is part 1. We have few more parts. So please stay tuned and listen to it so that the problems and solutions with respect to company law becomes easy for you. And thank you for listening. See you in the next session. Bye.